My name is Christy Hatting. Today we are very privileged to have a new guest with us, Asif Essa. Asif and I go back a very long way, and he's a very old friend of mine. And Asif has been in practice and very successful at that for approximately the past 30 years now. And of that, the last 20 years, he was the president of the KwaZulu-Natal Law Society. Before that got unbanded, and thereafter he's been appointed as the chairman of the Legal Practice Council of KwaZulu-Natal. So it's indeed a really big privilege and an honor to have him tonight, and to share with us his story and some of the insights of his career. Enjoy. And remember, if you enjoy the content and you like what we're doing, please smash that like button and become a subscriber so that we can stay in contact. And I'll see you on the other side of this. Evening, Asif.
Good evening, Christy.
And welcome here with us at our podcast Lex Events. It's wonderful having you here tonight.
Thank you very much. Wonderful being here.
Asif Essa is not a name that's going to be ever forgotten in the legal fraternity here in KwaZulu-Natal. That name comes a long way. There's deep footprints wherever those footsteps have gone. But tell us about the journey. How did you get to where you are now?
Christy, I'm part of a family in Pietermaritzburg that is business orientated, suppliers of fresh produce. So the thinking was either in the business or pursue some profession. And the choice was fresh produce business or become an attorney. And that's where the journey started.
Okay. And you studied here locally at KZN?
Studied at University of KwaZulu-Natal in the Pietermaritzburg campus, which was a very small and cozy practice or institution at the time. And that's where I did a Bachelor of Arts at the time, and then did my LLB in the small faculty at UKZN. And once I qualified, I then pursued other qualifications like a diploma in taxation, and then I wrote for a master's in 2003 in business law.
In business law. And did you finish that?
Yes.
Okay.
I finished that under Professor Bob Williams and attained that Masters of Law in 2003.
Okay, I didn't even know that.
Yes.
Interesting.
Yeah.
Asif, in your practice today, what are you mostly concentrating on?
Today, I'm in a practice in Pietermaritzburg where I concentrate on three aspects. One is the regulation or organization of the profession, being involved in the professional bodies and the structure of the profession. I also I love the whole issue of legal costs and taxations and all the other ancillary issues relating to legal costs. And I also do civil litigation. So those are the three components of my being as a legal practitioner. Yes.
Okay. Asif, now you and I have gone back a long way, and as far as I can recall, it's about 2 decades now that you've been involved at it was formerly the Law Society, and today you are the chairman of the Legal Practice Council of KwaZulu-Natal. Is that correct?
Yes. So my journey started out after having practiced for about 7 years on my own. I then became involved in an amalgamated practice, and thereafter I took an interest in the regulation of the profession. And in those days, it wasn't only the regulation, because the law societies were involved in both regulation and the trade union function of the profession. So I served on the KwaZulu-Natal Law Society for a period of about 14 years. And I was actually the last president of the Law Society. And when the Law Society ceased to exist, which was about 2018, the Provincial Legal Practice Council came into being, which was basically structured in each of the nine provinces. And after an election, we were elected. And for the first time ever, the legal profession is now represented from a regulatory perspective by both attorneys and advocates. So as we presently operate, the provincial councils have 6 attorneys and 4 advocates. So it goes a long way towards the unification of the profession, if you want to call it that, from a regulatory perspective. So I've served as the chairperson of the Provincial Legal Practice Council for, I think this is our 6th year. And actually the last year, because you are allowed and permitted to be involved in the council for 2 terms, and the term comes to an end early next year.
Okay, well, that's the profession's certainly going to be the poorer for that. But Asif, if we can just focus on our broader audience out there, the members of the public, people have such a lot of questions these days. They ask you, what is the difference between an advocate and an attorney? And nowadays, there are more generic names like lawyers and legal practitioners. So how would you answer that question for the people, if you can just explain to our broader audience?
I think for those who want to understand the difference between an advocate and an attorney, an advocate is a lawyer, and an advocate actually practices advocacy, specializes in advocacy, trial matters, and an advocate is permitted to do a number of things that is set out in the Legal Practice Act, in the Code of Conduct, as to what you're entitled to do. It's a broad spectrum of areas, but usually you are instructed by an instructing attorney, save that under the present era you have trust account advocates, so you are permitted to do work and have a trust account as well. So that's a new advent post the Legal Practice Act. But the difference is, an attorney is an, if you want to call it, all-round legal practitioner, where you're entitled to do a number of or practice a number of areas of law, whereas an advocate usually specializes in advocacy and courtcraft. And if you look at the definition actually in the Legal Practice Act, in the Code of Conduct, it tells you that it's not a closed list, but it should not be areas where usually an attorney would function. So that, in a nutshell, is basically the difference between attorneys and advocates. A lawyer is both an attorney and advocate. It could even be a professor of law. So it's I would say it's a generic term for a whole array of individuals who are involved in law.
Okay, I think that's a very good explanation. Asif, now the functions of the Legal Practice Council. It's a body that oversees as well. They do have a policing function as well over their members. So if somebody crosses the line, they're in breach of the conduct rules and so on, what does a member of the public do about that? And thinking about members of the public are often intimidated by legal professionals. They think that that they're going to get beaten by the in the arena that they're the weakest at. That's why they went to a legal professional in the first place, and then they get people are afraid of legal professionals because sometimes they get screwed over. How do you handle that within the confines of the Act and the Legal Practice Council?
So, as I indicated earlier, the Legal Practice Council comes after the abolition of the law societies. So the law societies used to be out there to protect members of the public. Basically, the purpose of the Act, the new Legal Practice Act, talks to the best interest of the public, the protection of public, and right to access to justice, etc. So if you're a disgruntled member of the public, then you have rights on the basis of what an attorney or a legal practitioner these days, because a legal practitioner is both now attorneys and advocates, how they ought to operate. And legal practitioners are bound by a regulated and codified code of conduct. It's in the Legal Practice Act. For example, if you overreach your client in the sense of charging him too much, that could amount to misconduct. In terms of the provisions of the Act, there's a whole array of misconduct. And in the event of you feeling that you have been unnecessarily taken advantage of by your legal practitioner, you then would document a complaint to the Legal Practice Council. And in particular, the provincial legal practice councils, who are the first step towards complaints. So, for example, in KwaZulu-Natal, the provincial administration of the Provincial Legal Practice Council would receive complaints, and then the practitioner would be asked to answer to those complaints. And the disciplinary processes involve, firstly, an investigative process. So there'll be investigation, there'll be assimilation of information. And then if it is found that there's a case to answer or a complaint to answer, it could go to the disciplinary processes. The Legal Practice Council or the Provincial Legal Practice Council have limited powers to the extent that we could ask for the suspension of a practitioner or an interdict. But as far as applications for the removal from the role are concerned, those go to the National Council and they make a decision as far as striking off of practitioners.
And that happens at national level?
That happens at national level.
Okay.
But there are disciplinary processes that are transparent processes. And also now, with the advent of the Ombud, you have another layer of protection as far as the public is concerned. So you have a legal services Ombud, which is presently in operation. And that also is another level of protection as far as the members of the public is concerned.
Okay.
So I can give you the assurance that the public are protected.
Okay.
From that perspective, yes.
Well, that's good to know. Asif, but getting back to the overreaching, the question of costs and charges, that's something that I've been quite vocal about in my LinkedIn following and so on. I've discussed a lot that my thoughts that I think that legal fees are prohibitively expensive and that sort of thing. What are your views on that in general terms, and where do you think we can make access to courts more available, more easily, readily accessible to people?
You see, I hear what you say about the issue of legal costs being prohibitively expensive, but I must differ with you to a certain extent in regard to that, because you have the right to negotiate with your legal practitioner, for starters. So it's a question of negotiation, a contract. In fact, Section 35 has a provision where you could even be asked, although it's not in operation at the moment, but it talks about a quotation up front. That hasn't been regulated as yet. But certainly, if you attend upon your attorney, you could ask and for what the litigation would cost. And then it's a question of a contractual arrangement. The issue of a fee, a reasonable fee, takes into account a number of factors. It takes into account the nature of the matter, the amount of papers that you need to peruse, the importance of the matter to the client, the geography of where those services are being rendered. For example, services being rendered in Sandton in the heart of Johannesburg may be different from what you would charge your client in Richmond in KwaZulu-Natal. So there's a whole array of factors, but it's a question of supply and demand. And one of the issues that was meant to be investigated upon in terms of the Legal Practice Act is the whole issue of legal fees. And the South African Law Reform Commission has actually presented a paper after doing extensive investigations. And it was,
sorry to interrupt you there, but you were quite involved in that process, weren't you?
Yes, I was involved to a certain extent because there was a task team from the Law Society of South Africa that made representations to the South African Law Reform Commission on this issue, and I presented a paper on non-litigious fees. But the point is that there is a paper that has been presented by the Law Reform Commission that has been presented to the Minister. So that discusses the whole question of legal fees, and it talks about the poor and the indigent, and then the missing middle, and then you have those clients that can afford legal services. So, for example, if you go to a large multinational, they have legal advisors in-house, and they can negotiate with their lawyers with regards to what fees are going to be charged. So I don't think it arises at that level, but I think it arises at the level of those that are indigent and maybe the missing middle, and that's been addressed by the South African Law Reform Commission. And I think there one has to consider the issue of the state. The state, in my view, ought to consider an enhancement of the justice centers and the legal aid boards to cover more civil matters and the threshold when it comes to civil matters.
So just pause there. So what was the problem with the quality, the level of legal services that those legal centers and so on provided, legal aid, for example? And what is the difficulty there?
I think that it's not so much about the quality; it's about the threshold, and I think the threshold needs to be enhanced. So when you talk about earning a certain amount and being qualified to approach the legal aid or the justice centers, I think that needs to be enhanced. And I think also what needs to be enhanced is a bigger budget by the South African government and the ministry with regards to justice centers, so more people can access from both a civil and a criminal perspective the justice centers. And if that happens, it's like, to give you a comparison with the health profession. If I'm sick and I can't afford a doctor or a hospital, I have a government hospital that will seek, to ensure that my needs are attended to. In the same way, one should consider justice centers analogous to hospitals. And so the member of the public can go into a hospital or a legal justice center when it comes to a legal issue and ensure that his legal issues are resolved. But I want to give you the assurance that from the legal profession perspective, lawyers get themselves involved in a number of different aspects in order to ensure that the members of the public have access to the profession. There is compulsory community service that's going to come in the offing. So legal practitioners must give off their time free of charge in legal clinics or whatever. Then there's the Contingency Fees Act, and if a member of the public is indigent and cannot afford legal services, provided it falls within the ambit of the legal of the community, the Contingency Fees Act, then one can enter into an agreement in terms of which you could have no win, no fees, and there's otherwise there's an arrangement that can be made in terms of the Contingency Fees Act, in terms of which you can access the courts. So there's a number of different interventions, and I can give you the assurance that members of the public can even have access to attorneys who, in certain instances, will act pro bono, depending on the cause. So the legal profession is mindful of these issues and the fact that there needs to be access to the profession. And from that perspective, I think that the legal profession does its part, and much more, in my view, to certain other different professions.
Okay, well, that's good to hear. Asif, the talking about the contingency fee agreement situation, what can a legal practitioner charge in terms of a contingency fee agreement that's allowable under the Contingency Fees Act? Because a lot of the members out there in the public don't know what the limits are.
The provisions in terms of the legal practice, or in terms of the Contingency Fees Act, is that it's regulated in terms of that act, and any agreement contrary to that act is an unlawful agreement. So, for example, if one enters into a contingency fee agreement, it must be in writing and it must set out exactly what the parameters are. The percentage at the moment is 25%, but it's not a common law contingency. So, for example, if you come to me as an attorney and I settle your matter in 5 days' time, I can't charge you 25% of the award. So the provision is that you can charge 25% or double your normal fee, whichever is the lesser. So if I've done work for a week or two, I can charge double my fee, but that doesn't amount to 25% of the award, because you may be entitled to a good couple of million rand, in which event it would not be commensurate with the claim.
Yes.
So there are basically limitations, and the limitation on a very general level is 25% of the award or double your normal fee, whichever is the lesser. But I must caution that contingency fee agreements can only be concluded in certain instances, and there could be abuse. For example, if you are involved in a criminal matter, you are not allowed to charge contingency fees based on success in that particular matter, depending on the charge, etc. Also, in deceased estates, contingency fees, in my view, are not permitted. So it's basically in claim sounding in money. It's in respect of damage, personal injury claims,
that sort of thing.
RAF claims, those kind of things.
Okay, I'm with you. And moving over to the cost side, when you recover, let's say you're successful at the end of the day and you recover costs, there are different scales of costs. What are those? Can you just break that down for our
Yes.
audience and let them, because it's very difficult for people out there, and it's a question I often get in practice. People say, "Yeah, but now if we win, does the other side pay my costs?" And
Yes.
do I do in other words, do I get your services for free? That's the hidden question. They don't. Would you mind explaining that to our audience, please?
Yes. So basically, they firstly they're different scales and they're different um, tariffs that are applicable as well. So firstly, let's get to the contingency fee area. If you win your case, for example, in a damages claim, then your attorney will charge you either the 25% or the double his normal fee, whichever is the lesser. But you're also entitled to then claim costs from the opposition. Those are usually party and party costs, and they belong to you, the client, because you would have already obviously from the award, your attorney would have been able to claim whatever the amount is in terms of that agreement. But as far as costs are concerned, party and party costs are usually those costs that you would recover from the unsuccessful party in litigation. From my assessment of being involved in costs over the years, that is not a substantial amount, because those would be the attorney and own client costs. So there's a difference between what you would receive from your opponent, because of the fact that um, you do not want to disadvantage an unsuccessful litigant to the extent
Yes.
that he'll pay prohibitively large costs.
Yeah. For example, if you're involved in a divorce matter where you have a, a very perturbed client who's emotionally scarred with with the process they're going through, you're not only the attorney, you become the psychologist as well. Now they phone you 3-4 times a day. I mean, that's not the opponent's fault that they're phoning you. Those are attorney and own client costs.
Yes.
those
So
aren't those aren't party and party costs.
absolutely. So
Sure.
there's a big difference between the two. And to that end, party and party costs are those which you would usually recover, which the terms that I use are reasonable and necessary. Then you get attorney and client costs, which is basically higher than the party and party costs. And then you get attorney and own client costs. There's one judgment that says attorney and own client costs is a component of attorney and client costs. So a full indemnity for costs is basically, or as close as possible as you can get to a full indemnity for costs, is attorney and own client costs. But the bottom line is you get those when an agreement permits that, or it's usually a punitive order for costs. But when you win your case with costs, that does not mean automatically all costs.
Yes.
And
And
when you
it's not
talk,
an indemnification for all the costs that you've forked out.
absolutely.
Oh.
And also you have scales of costs. For example, in the magistrate's court, those scales of costs are depending on the quantification of the claim. And in the high court, you have scales of costs allowable to advocates, which is a recent advent in the profession in terms of the rules, where there are different scales of what your advocate can recover, and that's been introduced since April of this year. So, as far as costs are concerned, you have to be mindful of the fact that I think upfront you should discuss those issues with your attorney from the perspective of what you're going to pay him, and at the same time from what you would be entitled to recover at the end of the day.
Okay.
But if you ask me, if my client comes to me on the first day and asks me how much will it cost, my answer to him will be how long is a piece of string.
Yeah.
It's very difficult to ascertain. A divorce matter could last a couple of months. In 6 months you can finalize a divorce, and then in those more complex matters where there are lots of issues and disputes, it could take 4, 5, 6 years.
Yeah.
Yeah.
No, you're absolutely right. So just to a party and party cost order, just to put it into practical terms for our broad audience out there. If you get awarded party and party costs and your actual bill to your, say you've actually paid your attorney 100,000 rand in fees and total fees up to that point, what are the percentage that they're likely to recover? More or less. And I'm not going to hold you to a particular figure, but just can just try and illustratively point out to the audience what the difference between party and party, attorney and client, and attorney and own client.
Just to give you a perspective from Pietermaritzburg, I would think that as we stand here today, your party and party costs are just over about 1,600 rands per hour. And if you look at attorneys in Pietermaritzburg, I think attorneys in Pietermaritzburg charge anything between 2,500 and 3,000 rand per hour. So if you want to make that, obviously I'm talking about senior attorneys now.
Yeah.
The junior attorneys will charge anything between the tariff and maybe 2,500 rands per hour. So that's what my feeling is at the moment. But for example, in the bigger centers, you'd find attorneys charging even much more than that, 3,000 or 4,000 rand per hour. And that has to be compared to what you're entitled to recover as we speak today is just over 1,600 rand per hour. That tariff has just been increased in September of this year and will last probably for the next 2 years. It's a recovery tariff.
Asif, and thinking now of the younger generation coming through, there's a lot of competition out there these days. There's a lot of people entering the profession. There's a lot of barriers to entry the profession. What are your views on those?
Yes, I think that there's a lot of change in the profession. I've now been a practitioner now for about 34 years. I still recall when we started out, you in the firm that I was in, which actually specialized in debt collection. One of our functions where we used to go out in the morning at 4 o'clock in the morning to arrest debtors. Now we're in the constitutional era. So to that extent, lots of things have changed. So in the old era, for example, you didn't have things like artificial intelligence. You didn't have issues like social media, etc. So to that end, the newer generation, in my view, are much more advantaged from that perspective. I also recall that in the initial years of practice, you were practicing with typewriters, and there were no issues such as there was no internet, and there were no systems that we have from an IT perspective that we have right now. The new generation are much advantaged when it comes to those particular issues. So when I started practice 3 decades ago, you didn't have all of that. Now you have, on the touch of a button, you could get legislation on your computer. So to that extent, you are in a great advantage. But having said that, I still recall in a matter that I was involved in recently, where there was a senior advocate involved, and there was discussion of a virtual hearing. He became quite, stressed out as far as that is concerned, and to ensure that he was more comfortable, we actually had like a mock trial where we had to set up, an area where we could have this virtual hearing or a mock virtual hearing. So the new generation of professionals are not going to be intimidated by social media, etc. And so to that end, I think practitioners are at an advantage. At the same time, I can give you the assurance that being a practitioner for about 3 decades, I can't see myself having done anything else. I certainly can't see myself having been selling fresh produce or anything of that sort, which was my family business in that area. But if you ask me now, I'd say I love 90% of what I do. Sometimes that 10% overwhelms you, but every day as a professional in the legal fraternity, it's like a different day that you're having, and it's something that I won't exchange for anything.
Okay. Now, Asif, if you could travel back in time, if we could send a message back in time to the younger you, 10, 15, 20 years ago, what would that message be?
I think that I don't think I would want to change anything that I've done 10, 15 years ago, because it was a journey and I had to find myself. I don't think you can be a jack of all trades. But right now, the 3 components that I'm dealing with in my professional life are things that I absolutely love. So when I get up in the morning, I'm dealing with one of those 3 components. And I had a chat with a friend recently when I said to him, this is what I love. And I think the answer would be that in my latter years, I'd like to slow down on one or maybe two of the three components that I do, but I still want to be involved in the profession. So I think it's necessary to actually go through the journey, to actually find out what in the legal profession attracts you.
Yeah.
Because I would hate for the person who goes to his office every morning and is frustrated or is not happy with what he's doing.
Yeah.
So the most important issue is you got to find that area of law that you love what you are doing. And for me, it was litigation. And in the early days, I still recall an incident where a client of mine came to my office and said, I've got the summons for 100 Rand and I want it to be defended. And I want you to use this advocate to actually deal with the matter. And I said to him, I don't mind paying the 100 Rand for you, but I don't think it's going to be possible. From a commercial perspective, you're not going to be happy because it's going to cost you a lot of money.
Yeah.
And he said, no, but I want to, as a matter of principle, I want to defend this matter. And I want you to use Advocate X to represent me. And I still recall I was a very young practitioner then. So I instructed this advocate. The fee was 100 Rand for some services that were rendered. I got this advocate, and I must tell you that advocate specialized at that time in criminal law. So he didn't know much about civil law, or I don't think he did, but he gave an excellent account of himself. And I still remember sitting next to him in that matter where he was cross-examining the witness. And I was sitting next to him as a young attorney. And the witness gave an answer that I found very amusing. Although it wasn't, I knew it was going in our direction. So I actually laughed at the answer that he gave. And that's unbecoming of actually a legal practitioner. But I was a young fledgling attorney at the time. And the witness said to the magistrate, I can see the attorney is laughing and giggling there. And I don't know what the need of that is. And I just put my head down and I learned my first lesson as far as the legal profession is concerned, and that is the decorum of the legal profession.
Keep your mouth shut.
Absolutely. And I can tell you that that claim against my client was dismissed, and we got a cost order against them, the opposition. But that was the first entry as far as legal practice is concerned. And that sort of atmosphere in the courtroom and what happens in the courtroom really attracted me to the profession. And I often tell people that you can't predict what's going to happen in the courtroom.
Yeah.
And I remember two instances. The one where we were in an appeal court and our opposition after the matter, I think he's one of your colleagues, he came up to us and said, I was riding, I was dealing with a tough matter. We had no chance whatsoever. Congratulations, guys. When the judgment came 3 or 4 months later, the judgment was totally against us. And there was another scenario where I recall coming out of a court and saying to my advocate, I said to her, when this judgment is being delivered, I want to be nowhere near this court. And 6 months later, the judgment was delivered and it was in our favor. So I often tell my clients when they ask me, well, are we going to win this matter? Or, what's the prospects? Can we have any guarantees? I will never profess an answer from that perspective because anything can happen. A matter can turn on small issues.
On small issues.
And that's what makes this profession so exciting.
It is, eh?
Yes.
Somebody once told me and said to me, if you want to know what your chances are, just look into these books that we've got here, because all of these books are legal cases, and in every one of them, there's a winner and there was a loser.
Absolutely. Absolutely.
So you never know which one you're going to be.
You never know which one you're going to be. But as long as you stay on the right side, a most important issue in this profession is stay on the right side of the ethics of this profession. And when you talk about ethics, I still remember, it may have been about 2 decades ago, where I used to lecture at the Professional Legal Training School on ethics. And you look at these books, and there's not many publications on ethics. I recall there was a book called Lewis on Ethics, and there was a Lewis's Golden Rule, what you must do. And I said to my students when it came to that, I said, you have Lewis's Golden Rule. Now listen to Isa's Golden Rule. When in doubt, stay out. That's what I mentioned to them. And actually, we tried to even enact certain scenes. And I still recall this incident in my early years of practice when I used to lecture at the Practical Legal Training School. They thought, let's make a video where we can enact certain ethical issues and what you should do in certain ethical matters. And I recall that the director of one of the PLTs and myself, we were then told that you need to give the introduction to this whole issue, and we'll have professional actors that will enact these scenes from ethical issues. So we arrived in Cape Town on that morning, and it seemed as though a few of the actors were absent. They didn't come. So I volunteered myself. I said, look, I've got some Bollywood experience. So I'll enact the scenes. And Kasi, we enacted those scenes, and quite frankly, the message went through as far as how you would acquit yourself in certain ethical issues. But the most important issue, in my view, being an attorney, is remember honesty, integrity, and reliability.
Yeah.
If you can tick those 3 boxes for the entire duration of your legal career, and know from a litigation perspective that you're an officer of the court, your first duty is towards the court, you'll go a long way.
Thank you, Asif. That's a very, very, very good message. I really appreciate that. How about a cup of coffee?
I'd love that. Thank you, Christy.
Thanks, Asif.